Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medical legal issues in our jurisdiction and provides hopefully helpful advice and guidance on how to manage those risks. So this current series focuses on demystifying the Medical Council standards. And today I have with me Dr. Sam King, one of the medical legal consultants from Medical Protection Society. Hello, Sam.
Hey, Lucy.
And I've also got Mr. Adam Holloway, who is one of the partners at Wood & Kearney, the panel law firm that work with MPS. Hello, Adam.
Hi, Lucy. How are you doing?
So I'm Lucy Gibbard. I am one of the other medical consultants at Medical Protection. So look, we're going to start with a case, and today we're talking about disclosure of harm following adverse events. And in this particular case, which is an HDC case, the patient had progressive eye disease, affected their cornea, and she'd had previous corneal transplants to restore her vision, which had failed. In this particular occasion, the ophthalmologist performed a third corneal transplant, which was initially an uneventful surgery, but unfortunately prior to suturing the corneal tissue to the eye, the ophthalmologist discovered that the donor tissue had actually been treated with Lasix, which is actually an exclusion to using such donor tissue for the procedure. I'm not an ophthalmologist, but apparently it's very hard to see that the cornea has had Lasix, and on this occasion it had been missed in the initial checks. So at this point, it was neither practical nor safe to wake the patient up to explain what had happened, as had he done so, she would have lost the eye altogether. The old donor cornea had been removed. So the ophthalmologist decided to continue with the surgery, and he believed that there was a chance that the new cornea could work successfully, despite the fact that it had had Lasix. The actual surgery was uneventful and the patient was reviewed on the ward round the next morning, but at that time was not told of the issue because the surgeon thought that actually it was better to tell her later when there was more time to discuss and address her concerns and when she could have a support person present. And he thought in the situation of a post-operative ward round where there was limited time and limited privacy, it would be too stressful for her to tell her. So she had an outpatient appointment 2 weeks later, and that is when she was told about the issue with the donor cornea. Unfortunately, that cornea did fail, and the patient laid a complaint with the HDC. And the commissioner looked at this issue and what was the right thing for this doctor to have done at the time when he realised the cornea had actually been treated with Lasix and wasn't suitable for grafting. So the commissioner agreed that the surgeon was right not to wake up the patient, and that continuing with the surgery was reasonable, hoping that the outcome was good. However, the commissioner found that the ophthalmologist was in breach of Right 6.1 of the code because he failed to disclose the issue of the compromised donor cornea until 2 weeks after the surgery, despite the fact that actually when he disclosed that didn't actually have any effect on the outcome. So the question here is, when is it too late for a disclosure of an adverse event? In this case, the surgeon knew there was nothing to be done. They were going to have to wait and see if that graft was successful. And in that situation, thought it was best to wait and have a full and frank discussion at a later date rather than telling her on the ward when there was limited time to answer questions and limited support. So, Adam, Sam, what are your thoughts about that? What do you think, Sam?
It is really difficult to know exactly the best moment to make an open disclosure. And I think it depends on each situation as to when the optimum time would be. In looking at this particular case, I would have thought that, in fact, 2 weeks is a long time, presuming the patient had recovered from the operation per se very quickly. It's different when you've got a patient who's in ICU, for example, post-op. That's not a good time to be telling them anything. But if the patient was on the ward physically well, and I presume could have called in a support person for a discussion, then it would have been ideal for the doctor to have talked to the patient about it sooner. And clearly there was an HDC complaint, so the patient presumably felt the same. I don't know, Adam, your thoughts would be good.
Yeah, I guess, and these things are hard, and they have such a close relationship to clinical judgment, and it's something that's always hard for a lawyer to offer an opinion on. But I would say you don't always have to wait until the circumstances are that you can do a perfect job of open disclosure. I think often there's a sense that I need to wait for the absolutely best moment and where I got all of the information. So, how did the cornea reach this point without us realizing that it had Lasix, for example? You don't need to always do all of the job at once. So if there is that opportunity earlier on to say, look, there was a complication, things didn't go to plan. We just wanted to let you know that now. There's nothing, no urgent situation arising we need to deal with now, but I just want to let you know that and make a time where we can go through what happened with you. Would it be helpful for you to have your partner or your friend or your support person present for that? And also want to make sure that you're feeling well enough post-surgery. How are you at the moment? You can start the conversation, and even if it had been a brief conversation, I think things may have played out quite differently for the HDC if they'd seen that had started rather than there being nothing until 2 weeks. I think any patient learning that a surgery had not gone to plan a fortnight later is going to be quite surprised in an unhappy way.
The problem is often doctors do want to kind of, when they tell a patient about an adverse event, they often want to have the solution at their fingertips at the time that they disclose that. So they're often trying to sort out the next referral or some kind of solution so that they can tell the patient at a time when there's a solution. But really what you're saying is if that involves a significant delay in telling them, you've got to not wait for that and just tell them and then say, and I'm seeking a solution, even if I haven't got one yet.
That's right.
And it does seem like the medical council statement is along the lines of what the HDC said in this case, that they think it should be as soon as possible. So look, today we are looking at the medical council statement on disclosure of harm. It's a pretty old statement, actually. It's from 2010. They often update their statements. This one hasn't been updated for a while. But there are also a couple of other resources which are good to consider on this subject. There's the HDC guidance on open disclosure policies, and also the Health Quality and Safety Commission has a document on how to engage with consumers following an adverse event. And look, both of those are quite thorough as going through what the expectations are. So I think they're useful to read alongside the medical council statement if you're looking into this. And interestingly, the medical council statement has this discussion regarding the difference between the patient and the doctor's expectations from disclosing harm. They're suggesting that patients want to know what and how the harm occurred, why it happened, what the long-term consequences are for his or her care, and they want to know that systems have been fixed to stop that happening again. Whereas often doctors may be more concerned that the patients aren't overwhelmed with technical details, and they're worried about actually upsetting the patient further, who's already unwell and something, has had an adverse event happening to them. You don't want to actually make things worse with your own disclosure. So, Sam, have you got any thoughts about that?
Yeah, I do. I've spoken to many doctors where they've had a sudden and unexpected adverse outcome, and they may or may not be to blame for the adverse outcome. And studies have revealed that 50% of adverse outcomes were unavoidable. But I think when an adverse outcome happens, most of us jump to the conclusion of, I've done something wrong. And, doctors react in quite strong ways to that. And often we're afraid of talking to the patient because of how we think they might react, and often they're angry, or their whānau become very angry, and that can be a really challenging situation to have to be in. And of course, at Medical Protection, we talk doctors through the process on a regular basis. So, it's really helpful if you are a doctor in that situation that you do call your indemnifier and take some advice, because there are some really good steps that you can follow that will help you get through that process. So even though it is challenging for the doctors, and where the patients may in fact be very distressed, or their family very distressed when you have the conversation, I think ultimately you get resolution faster. And I think there's less pain for all concerned if you do it early and do it well.
And I do think there is often that automatic desire to withdraw. We have a human desire not to cause distress or be involved with an angry person. So often doctors don't want to be the person, or they'll leave it to someone else, or they avoid talking to the patient after an adverse event has happened. And it takes a bit of courage to actually take the first step and raise the issue with the patient. But I think it is definitely best in the long run, as you say.
I guess the opposite can happen too. Some people's reactions will be to withdraw and avoid starting that conversation, or want to have possession of all of the facts and the answers before they engage in it. But another thing that we see sometimes is people whose reflexive response is to not just acknowledge that there's been a complication or that something's not gone to plan, but then shoulder all the blame for it, even when they're not really sure why something went wrong. And again, that can be quite a human reaction to just say, well, look, I'm the most responsible person here, it's on me. There are ways of saying, look, I'm really sorry that this has happened, without conveying that necessarily all of the whys or wherefores. And while you might feel that you're doing the honourable thing, it can have unforeseen consequences, and it can actually, down the line, erode trust if it turns out that there is a serious incident review, or things are looked into, the whānau still looking for answers, and suddenly they're getting different answers. That while a surgeon had a conversation and said, oh, look, that was my fault, I didn't open the drain in theatre, when it turns out, in fact, that was something that happened post-op when the suction bottle was changed. So, there are right ways of doing it, and big emotions in play, which is a good reason why it's helpful, I think, to slow down and seek some advice.
And to stick to the facts often, to say that this is what I know has happened. I don't know why or how, but actually we are going to look into that and get back to you, so that you stick to the facts. And I often think talking to a colleague or to your indemnifier before you talk to the patient or their family is often a good, to get some reflection on how you're coming across it is useful. So the council also point out that doctors may be reluctant to disclose harm to a patient and family because they're worried about eroding trust between the doctor and the patient in that relationship. But they're also worried about liability and the possibility of a complaint. So look, do you think that actually addressing the issue before early and actually disclosing an adverse outcome, do you think that actually makes a complaint more likely or less likely?
I certainly don't think that it makes it more likely. Some people will want to complain no matter what, but actually starting that conversation often creates an opportunity to build trust and to bring people into that understanding that, look, something hasn't gone to plan, but we do intend to find out why, and we do intend to take the steps we need to remedy the situation. So I would never take the view that holding on to this information or not sharing it will somehow protect you from a complaint. Usually the truth comes out one way or another, and you'll be better served by having made that early disclosure. It's also, as I've said earlier, I think, absolutely possible to say sorry, express regret, without accepting liability or blame, because at that stage you don't know all of the facts. So you can say, look, we're really sorry this has happened to you. You can even say, look, I wish we hadn't had this outcome. Those are very easy and good things to say that are likely to be well received, which don't then accept, in the absence of all the facts, that you're necessarily to blame. So often when doing that first stage of disclosure, it's best just to say what you do know. So state the facts about what's happened, and don't try and give the explanation of why it's happened. Just say, look, we've had this outcome, we know this has happened, we will be looking into it more. I'm really, really sorry this has happened to you. And that's enough to get that conversation going and starting to build or rebuild the trust with the patient.
I think it's quite commonly thought out there that if I say sorry for anything, that it's an admission of blame. And I don't know where they've heard it, but it's like never say sorry, like never make an acknowledgement. And I think that that's actually wrong advice, that patients do want empathy, and part of that empathy is acknowledging the fact that they are distressed, that a poor outcome has happened, and that you're sorry that it's happened. And I think that our listeners should feel reassured that in making those statements, there is no acceptance of this was my fault. In the same way that you might say to a friend, I'm sorry for your loss. It doesn't say, when their parent has died. And it doesn't mean that I'm responsible for it, but we're acknowledging that we are sorry that they've lost a loved one. And I think if we can do that well, it certainly does take a bit of the heat out of it for families. And a good open disclosure process, I think, really does reduce the risk of complaint. And I think there are studies that confirm that.
And also walking alongside the patient, after an adverse event, it is so important that you stay involved and, try and overcome that wish to withdraw. Actually, staying involved is definitely good. And we so often see in complaints at medical protection, that an adverse outcome occurred. It may have been no one's fault, but then the doctor didn't follow up with me. The doctor didn't say anything. The doctor didn't come, so that actually it's the lack of follow up afterwards which has actually caused as much distress, and has actually been the impetus for the complaints rather than the actual adverse outcome. And look, the council do say that initial disclosure should be as soon as possible, but they've also acknowledged that sometimes actually giving the patient that information in stages when they've got support is actually the right thing to do. And they say while it may be more appropriate to disclose harm in stages so the patient understands and processes the information without being overwhelmed, ongoing delay in giving full information is only acceptable if this is in the patient's best interest. So in those situations, you've just got to think about how you're going to carry on providing information. You need to actually give the patient an idea of timeframes and when the next step will be, as much as you can, and keep in touch. So look, the council statement suggests that a team meeting would be a good idea to establish what actually happened and to get the views of all staff involved. But doing that shouldn't delay telling the consumer. So Sam, who do you think should actually tell the patient after an adverse outcome has occurred? Who's the right person to talk?
When you're talking about a hospital situation, usually it would be the most senior member of the team, so the SMO. Especially if it involves a junior doctor who's actually made the error. And I think that's for a number of reasons. One, the consultant will know much more about the clinical situation. Often junior doctors don't have the experience and find the situation far too intimidating to be able to speak to the family. And, I often say to members, if they really are too distressed in meeting with the family, it's better that they don't, because things can worsen as a result. And, we all know of certain doctors who've needed to take stress leave, essentially, when something difficult has happened. So I think the most senior doctor is important. I think if the clinician involved in the actual error or in the adverse outcome is able to be present, that's always helpful as well. I think it's obviously the family need their support people there, but you need to think about how many people are going to be there for the patient. And if there's only two of them, that the patient and their partner, you don't want to have 4 people attending from the hospital. You really want to try and think about not overwhelming the family at those times. But if there are a larger number of family members in the meeting, then you might want to consider who does the patient trust and relate to well in the team, and that might be a nurse, for example, and that can actually be a reassuring thing for family to have someone in the room who is part of the clinical team but whom they do trust, and it can really help with good communication.
Yeah, absolutely. And look, the other issue is what happens when the consumer or the person where the adverse event has happened is unconscious or is in ICU, like you were saying earlier. At what point are we obliged to tell the next of kin? There may not be an EPOA or somebody that is easy to tell. So, Adam, I don't know, what do you think about that? Do you think after an adverse event, if something happens in theatre and the patient's in ICU, what do you think about informing the next of kin?
Yeah, I mean, I guess sometimes there'll be an obvious black and white legal answer to that if there is an EPOA, or if the person who's experienced the adverse event as a child, then there'll be a parent or a guardian to speak to. But the next of kin doesn't need that black and white legal status in relation to releasing an adult's health information. The Health Information Privacy Code caters for that, and probably the easiest, rather than going to that document, one of the easier reference points is the Health and Disability Commissioner, the HDC, has put out guidance that says, in circumstances where discussion with the consumer is not possible or appropriate, his or her representative or a suitable person who's interested in the welfare of the consumer and is available, such as their next of kin or a designated contact person, should be informed of that adverse event. So if the person becomes well again, there'll be a time to have the conversation with the patient as well. But don't wait for that to happen.
So you don't have to be worried about the privacy issue of releasing health information. If the next of kin is available, you're allowed to talk to them.
In terms of making that open disclosure, yes.
That's useful. And then, Sam, what do we actually need to do when we've had that conversation? Is there anything else we need to think about?
I think it's always important to document the discussion you've had. Obviously, when an adverse outcome happens, it's always advisable to go back and add an addendum to your notes if that's necessary. But certainly after a meeting with the patient and their family, you should document it carefully as to who was there in the room, and that keep minutes of exactly what took place. And in particular, any acknowledgements that have been made, any significant questions that the family have had, particularly if you haven't been able to answer them, and the plan moving forward. And usually in that plan there's some date set down as to when you will meet again, because there are answers that need to be sought. Like they've asked questions and you've had to go back and find more answers. So you want to set a plan for when you're going to meet next, and that should be documented so that you can stick to it. Because what you don't want is for the family to expect that you're going to contact them in a week, and then you find 2 or 3 weeks later they haven't heard from you. I think that those are really important things, and I guess that's part of what you were saying about earlier about just staying with the patient and not abandoning them, because I think that when patients feel abandoned after something like this, they're far more likely to want to complain.
Adam, have you got any other advice or anything else that you were thinking about with that?
Yeah, well, look, I agree with Sam about having a plan, particularly in a a bigger clinical setting like a hospital, if there's going to be a review, they can take a long time. The patient may need to get referred off to another service. It's easy to lose track of that patient and those contact points, so that you need to take advantage of the trust you've built by making open disclosure, and hold on to that and try and build on it if you can by maintaining the relationship. But the other side of the coin, of course, is to think of yourself, both in terms of getting help around the process. So if it's not going to cause significant delay, then you can consider discussing with colleagues about how to approach conversations or meetings. You can also talk to MPS, who's able to offer advice and support. And then more broadly, just your own well-being, I think, is important not to lose sight of, because being involved not only in something that's gone wrong, but also then in those high-stakes conversations can be really distressful, can be very distressing and stressful for the doctor as well. So nobody's going to be helped by the person involved in the error becoming unwell or not being able to cope themselves.
Yeah, it's interesting. The HDC guidance on open disclosure actually says, and points to numerous studies that have shown that most errors are made by well-trained people who are trying to do their job but are caught in a flawed system that predisposes them towards making mistakes. So even if the mistake is due to a person, it's often there's some organisational issues in there as well, and so that if you're the person who's made that mistake, you often take it on yourself without seeing those other things. So the clinicians involved really do need support from colleagues and from the system. It's interesting that the HDC guidance has that there, pointing out that actually the clinicians are normally well trained and are trying to do their job caught in a flawed system. Do we actually think that's reflects the HDC's approach when there's an adverse outcome?
Well, it's a big question, Lucy, that I could probably talk about for a long time. But I guess let me say this: I think the HDC is an important part of the system that we have. We travelled a long road before we got the HDC, and patients need and deserve a place they can go to raise these concerns. There are definitely worse systems out there. So I'm a real advocate for the HDC performing a role. And I also think it's understandable that the HDC doesn't see itself as in the business of excusing circumstances where what we all desire as being the standard of care hasn't been met. That said, and I can only guess at this from the outside, perhaps because of the amount of work the HDC has to get through and resourcing and just the grind of its daily business, perhaps it is the case that the HDC can lose sight of just how affecting its process is on doctors and other healthcare providers, and just how keenly the HDC's opinions are felt by those doctors. So it is really hard if you are in one of those situations where you feel like this was inevitable because of all of the things that were arrayed against you, to then be at the receiving end of a breach finding. I don't have a fix or a solution for that, other than to hark back to what I said earlier, which is that you can't lose sight of how important it is to remain supported yourself as someone who's been the subject of a complaint, because even with the best representation and even a good outcome, it can still be a long and hard road that many people will lose sleep over. So
I think that for the HDC, they often listen to the expert opinion that they will obtain for every case. And for the opinions that are of good quality, they will always take into account the environment, the systems issues, and they become mitigating factors. I think that the HDC seem variable to me in terms of how much they take into account the system issues. Sometimes the HDC are really good on that front, and other times less so. But ideally, I think, there does need to be an understanding of the pressures that doctors face and the circumstances that they work in.
So turning from the HDC to the Health Quality and Safety Commission, their advice, one of their points is that they really want to involve consumers in the adverse event review, which I'm not sure how often that really happens. They want to ensure that providers are thinking about the alternative perspective and get consumer insight into possible improvements and solutions to prevent future events. They've actually developed an 8-step guide to engaging with consumers following an adverse event. And I'm not sure if we have to go through every point in that guide, but if you're interested, you can go and look on the Health Quality Safety Commission website. But look, are there any issues with these that will be useful for us to discuss?
It's interesting to see that from the Health Quality and Safety Commission, and it makes me reflect on examples where the whānau of patients where things have not gone right really do get heard and really do have agency in the process, actually how positive and healing that can be. And one of the places we see that, which is not ideal because it often happens so long after the event and it's such a big to-do, but is in coroner's inquests because of the nature of a coroner's inquest and the very prominent role that whānau have and their ability not only to speak directly to the coroner but also to ask questions of witnesses. That degree of involvement and agency allows a lot of healing to take place. And it's interesting to reflect on that and try and transpose it much earlier in the process and think, look, if we could involve people and let them ask genuine probing questions and get genuine open answers, it can, I think, at least creates an opportunity for improving outcomes and reducing complaints ultimately.
I think that a lot of hospital investigations are delayed. They take a very long time to even get going. They take a very long time to conclude. And I don't know that that's helpful for the whānau to have something drag on and on and on. And I think I would agree with Adam that the more you can include family in that, the better. At least keeping them up to date, having them look at certain responses, etc., I think is really helpful. So the more you can do it, the better.
Yeah, and the Commissioner is suggesting that, getting consumers to look at the draft reports and comment on them, being able to give their story and making sure that the clinicians are actually communicating well about what's going on, what follow-up actions are going to happen, all those things. I think if that's done really well, you are probably less likely to get a complaint even in a significant adverse event, because essentially, it does at least reassure the patient and the whānau that it's being taken seriously and that actually people really are making an effort to make sure this doesn't happen again, and also to listen to what effect it's had on the family, because I think people often feel that that the clinicians don't really understand what the effect on the family and the patient has been. So I think, it's something we probably could do better, I think.
Lucy, there's just one thing I'd like to just draw our listeners' attention to. And, I know that you've experienced this as well. When one of our members has an adverse outcome, it's often devastating for the clinician. It is an incredibly stressful time, and often, because it involves a complaint process or at least an investigation process, it goes on for quite some time as well. And so I'd really like to just encourage our listeners, if that's you, if you're a clinician facing this process, to get your own support. I have spoken to members where they've said they haven't told a colleague, they haven't just been able to bring themselves to do that, or even necessarily family. And but I'd encourage you to share it with some trusted colleagues. You'll be amazed at just how supportive they will be of you, because all of us know that on any given day it could be us in that situation. So I'd encourage you to do that. And for our members, of course, we do offer some CBT free of charge. And so if you are our member and you need that, please avail yourself. I'm sure that your employer will have EAP available. If you're a GP, you can get EAP through the GP college. So please make sure that you look after yourself, not just your patient.
Thanks, Sam. That's very good advice. Okay, so look, I don't know if there's anything else particularly that we wanted to talk about in this statement, but I think the key learnings here pretty much, and going back to that case at the beginning, is, how soon do you notify someone about an adverse event, the patient about an adverse event? The answer is as soon as possible, even if it's only in a limited way. And then once you've done that initial exchange of information, you're actually just going to want to make sure that you've got a really good process to walk alongside them and keep them involved in the investigation of what happened, and to hopefully be able to give them some reassurance that steps have been taken so that such things won't be able to happen again in the future. Look, as Sam was saying earlier, so many adverse events are not due to an error, but that doesn't mean to say they're not things that we can learn from. So I think that's what I would suggest. So thank you very much, Adam and Sam, for coming along today. And we will finish here. So thank you for listening to the podcast. I hope it's been helpful. We look forward to catching up with you in our next podcast, Protection Podcast. Please subscribe and leave a review. If you'd like a podcast on a specific topic, please email us on nzpodcasts@medicalprotection.org. Thanks, and see you next time.